Senator Ivanovic, 8 minutes.
I'd like to welcome you to the House, Minister, to welcome your officials and to welcome all of those in the public gallery who played such a strong role in helping to form the shape and to influence this bill for the good. Those from the Immigrant Council of Ireland, Ruhama, ICTU and the INMO and the Dublin Rape Crisis Centre in particular, and I know there's many others who've worked on the bill. Minister, as you've said, it's a genuinely reforming bill. It brings in very substantive and significant changes to our law on sexual offences. If there's one overarching theme to it, I would say it's a bill that addresses sexual exploitation, in particular of children, as you've said, but also of those engaged in prostitution. And I'm particularly proud of the role that the Justice Committee has played, and to which you very kindly paid tribute, in terms of formulating some of the policy basis for the changes proposed in the bill. I would take very strong issue with some of the comments by Senator Mary White in relation to the changes in Part 3 of the bill, in particular relating to prostitution, and I'll speak on those in a moment. And I would absolutely agree with all of that Senator Zappone said in relation to Part 3 of the bill, sections 20 and 21, on the changes in prostitution law. Could I first, however, just turn to two other aspects of the bill that I think are particularly welcome. Part 2, which deals with sexual exploitation of children, and which Senator Noon has dealt with in detail. And I wholeheartedly welcome the changes here, in particular those in sections 16 and 17 that change the 2006 Act in respect of the defence of mistake and in respect, as you've said, of the issue of consensual underage peer relationships. I think these are sensible changes that will greatly enhance protections in our law for children. Could I turn then to Part 5 of the bill, dealing with criminal evidence provisions, and again just to welcome a couple of particular changes there, and there's some very important changes to our evidence laws. I think in particular section 33, to which you've referred, and which deals with disclosure of third-party records in sex offence trials, and I know how hard the Dublin Rape Crisis Centre in particular has worked on this. And indeed in this House, Senator Van Turnout introduced amendments on this issue in 2013, which I supported. So I know, I think, Minister, you deserve great thanks for bringing in these provisions, the careful provisions in section 33. I know from colleagues in practice what a huge issue this particular issue of disclosure of records, particularly counselling records in sex offence trials has been. And I think it's really helpful, it will be really helpful for practitioners, for judges, but most particularly for complainants, to see the clear criteria set out for decision making on this disclosure question. Could I also welcome in section 30 perhaps a provision that hasn't been much remarked on, a protection against personal cross-examination by the accused in sex offence trials where a witness is under 18 or under 14, and different provisions there. We have research underway in Trinity at the moment on the real trauma that can be caused to complainants where a defendant chooses to cross-examine in person, and currently there's no restriction on that, as you know, in Irish law. This, of course, will change that, but it has been a huge issue and a very high-profile issue in other jurisdictions, and I'm really glad to see us taking this sort of preemptive action. If I could offer a suggestion that we might consider extending this some form, perhaps a somewhat more limited form of protection, to adult complainants. Again, this has been done in other jurisdictions to some positive effect. Could I turn then to Part 3, which has been addressed in detail already by others, but sections 20 and 21, I just want to again agree entirely and support very strongly the new provisions here concerning purchase of sexual services. And just to point out to those who've commented on this, that these changes are supported by a wide range of organisations, including the Immigrant Council of Ireland, the National Women's Council, Ruhama and the Turn Off the Red Light campaign. But the change is only being introduced, as Senator Zappone said, following careful consultations, and in particular the long consultations that were carried out in the Joint Oireachtas Committee on Justice. And like Senator Zappone, I was proud to be part of that and part of the small group which travelled to Sweden and which heard direct evidence from those engaged in frontline implementation of the Swedish approach there. And can I just say, our committee received 800 written submissions. We heard from 26 individuals and representatives of groups, and we through public hearings, and indeed through hearings, senators may be interested to know that we heard from those for and against the Swedish approach. We heard from those engaged in prostitution, both for and against the Swedish approach. But we found, and I would ask colleagues to look at the evidence basis of our recommendations and at our report, which I think is a careful and well worded report, which sets out how persuasive we found the evidence on the reduction of demand for prostitution in Sweden since the introduction of the prohibition on buying sex there in 1999. We noted that 80% of the submissions to us favoured the Swedish approach, that these were drawn from a broad cross-section of civil society, including trade unions, frontline medical workers, service providers, and those working with migrants in particular. We also found, and again on the evidence that we heard, that prostitution is widely available across Ireland, highly organised, highly profitable and highly exploitative, largely controlled by organised crime interests. We heard that women enter prostitution in Ireland at a young age, many under 18, many are trafficked into prostitution, and the vast majority are subject to control by a third party or pimped. Even those witnesses who told us that they had entered prostitution freely and who argued against the Swedish approach said, and we asked them, that they represented at most 15 to 20% of those engaged in prostitution. So clearly there's a huge level of coercion and exploitation going on a daily basis across Ireland in the actual reality of prostitution. And yet we know, and I know as formerly a practising lawyer, how flawed our current Irish model for regulating prostitution is, based as it is on public order, on prohibiting the visible manifestation of prostitution through criminalising loitering and soliciting. And Minister, can I really welcome your undertaking here in your speech today that you will be bringing forward amendments in this House to further decriminalise those women and men involved in selling sex in prostitution by removing those who offer sexual services from the existing offences of solicitation and loitering. We didn't address this directly in our Justice Committee report, but we did follow up with you asking that you would add those amendments into the legislation. And I'm really glad and I really very much welcome your undertaking today. Because we argued, we found ultimately that the focus of our current law on regulating supply and on targeting those engaged in selling sex, because of course those convicted of prostitution-related offences are overwhelmingly women and overwhelmingly those selling sex. That focus we found to be flawed and to be ineffective, and we argued instead that we should adopt, as we are going to do in this legislation, a different approach which targets demand and which criminalises only the purchase and not the sale of sex. And similar to that introduced not only in Sweden, it's important to note, but also of course in other jurisdictions, including Norway, Iceland, Canada, and of course very recently our neighbouring jurisdiction of Northern Ireland. And there are real concerns, I think, and valid ones, that if we do not adopt a similar law, that we may become a safe haven for traffickers moving women south. So we know the immense levels of exploitation here in the sex industry. We know just how extensive that is. And I think this approach that we're seeking to adopt in sections 20 and 21 is a sensible alternative approach. But I would say that we did also find from our studies in Sweden and our research that Swedish law is part of a multi-policy initiative. It's not just a penal law approach. The Swedish authorities have also introduced harm reduction measures, initiatives to support those exiting from prostitution, and generally they've adopted, I think, a holistic approach to tackling prostitution. And that, again, is what we recommended in our report we should undertake here. So could I really strongly welcome this initiative? Could I quote from Monica O'Connor, who gave an excellent briefing along with Nusha Yankova earlier to colleagues on the changes. The idea of free choice in prostitution is a misnomer. For anyone who has investigated and looked at the evidence, we know that prostitution in Ireland, as elsewhere, is about exploitation and commodification, in particular of women, but of those selling sex generally. We know the approach adopted in Sweden has had a strongly positive normative effect on social attitudes to sexuality and to equality, and I think it's a really meritorious set of amendments that we seek to introduce.
Thank you, Senator.
So I'd like to just strongly support the bill and look forward to raising other issues, in particular issues around section 39 and around the definition of consent, which I have raised previously with your officials. And again, I would hope we might, Minister, that you might consider taking amendments on those issues. Section 39 in terms of vagueness of language on the indecency offence and the definition of consent in sex offences, which I know has been raised with you by the Rape Crisis Centres and the Rape Crisis Network.
Senator David Norris, you have 8 minutes.